All right, great. So good afternoon. Hi, Senator Eldridge. Great to see you virtually. Chair Day, thank you, members of the committee. It's a privilege to appear before you and to testify in support of Senate Bill 920 and House Bill 1826, raising the age of juvenile court jurisdiction in the juvenile court. I preface my remarks by saying that I am a retired judge of the juvenile court, as noted. I retired at the end of 2019. I was the first justice for Middlesex County Division, which is the largest county in the state. Prior to that, my experience was also informed by my 20 years of experience working with and representing young people, both juveniles and late teens in juvenile and criminal justice. I work also with Deb and Chris Friedis in the Mass Bar Association Section Council, and I'm affiliated with the Center on Law, Brain, and Behavior. You'll be hearing from Dr. Kinshirf as part of this panel shortly. I sincerely believe that raising the age of juvenile court jurisdiction is not only in the interest of positive youth development and aligning a policy with a developmentally appropriate lens in which to look at young people, but it is also a public safety imperative. Why do I say that? Well, I say that simply, if you look at any system, recidivism is an important tell of the efficacy of the approach. And the recidivism rates in the juvenile system are substantially lower in the criminal system. Research shows that within 3 years, 76% of persons who are released from jails and prisons are rearranged in our criminal courts in Massachusetts. This is contrasted by a dramatically lower recidivism rate in the juvenile court system. DYS statistics show that the recidivism rate over the past 5 years has varied between 25 and 28%. As Senator Cream cogently observed earlier during this hearing, over 70% of the youth who are currently in the system are youth of color, 70% of the committed population. Limiting entry into the system dramatically will affect and reduce, I believe, disparate representation of this population. Similarly, the model in the juvenile system of positive youth development is aligned with giving people a second chance and better protecting public safety. The DYS model, in which people are discharged at age 18 for delinquency offenses and 21 for youthful offender offenses, means that people then are free to return to the community. This is significant and is contrasted with the district court and superior court models, which foster, perhaps unintentionally, a never-ending cycle of probation and parole violations. These are the significant drivers of detention and commitment. It's interesting to note in this context that over 60% of the persons who are discharged from DYS voluntarily engage in services with the department after discharge in a program called Youth Engaged in Services. The acronym is YES. This is significant. To create a parallel structure in the district court would be onerous. And why try to replicate a system which already exists in the juvenile court system, which features not only a community-oriented DYS, Department of Youth Services, which features positive youth development, fosters educational continuity when it already exists. There are some models in the district court system, in the criminal system, notably in Middlesex and Suffolk, which have specified programming for older adults, but those are outliers. That is certainly not the state norm. Increasing the age to 19 at a minimum and then moving higher would automatically expand diversion opportunities. Right now, pursuant to Massachusetts General Law, Chapter 119, Section 54A, a wide range of juveniles are eligible for diversion. Many are eligible for judicial diversion and can have their records expunged. The majority of 18-year-olds who are now in the criminal system, many of whom are in high school, have their cases dismissed with court costs or continuances without a finding. However, they face the long-standing collateral consequences of having a criminal record. In addition to these factors, I'll conclude. In addition to these factors, it's important to note that many of the youth who are currently involved in the juvenile system are duly involved in both the Department of Child Welfare System as well as juvenile criminal justice. Juvenile courts have jurisdiction over youth 18 to 22. This affords a much more contextual lens to address these cases. Look, I'll conclude by saying I'll share this observation. When we raised the age to 18 in this state, everybody prophesied that the sky would fall. That did not happen. These persons were 17-year-olds were readily assumed into juvenile court population. The same will happen if we raise the age at least to 19 to start, while affording greater rehabilitative opportunity for a significant number of youth. And as regards the issue of capacity, DOIS is virtually empty. Delinquency cases are dramatically down. If there is a capacity issue, then I think the more affordable way going forward is to address that in the legislature by providing more resources for the juvenile court to already augment the DYS system and the statewide court clinic and the existing judicial resources that are available. I thank you for the opportunity to address these issues, and I will be submitting written testimony to augment my remarks, which is supported by approximately 15 retired juvenile court judges, including Superior Court judges, appellate court judges, and a former Chief Justice of the Juvenile Court. Thank you so much.